This is pretty much like contract bingo for what you shouldn't put in a contract and how many words can I use that really are unnecessary and add no value to the document.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, law professor, director of Emory Law's Tiger program, and former patent counsel Nicole Morris tears down a venture capital collaboration agreement. This one's unusual because Nicole actually uses this document as an object lesson for her students on what not to do. She talks about the confusing language, contradictory terms, and troublesome data provisions that plague contracts in the tech startup industry. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. The purpose in this show is to hang out with really smart friends like my buddy Nicole Morris over here to tear about contracts and talk about things we like and that we hate and want to make fun of in a public forum because we can. So today we are talking about a collaboration agreement. Nicole, how are you doing today?
I am well, and I'm actually excited about Christmas in the pandemic. Despite it being Christmas in a pandemic. So
you're a monster. I don't think we're ever going to finish decorating our tree. That thing has been up. It took like 4 days to get it lit. Now there's not stuff on it. It's never going to get done. I do love, though, every time I ask somebody in this pandemic, how are you doing? They're like, okay. So today, guys, we are going to talk about a collaboration agreement. And this is an interesting one because Nicole uses it in her law school experience. It is this document. There are a couple of parties. We've vagued out the names and we'll talk to you about why. But you've got an agreement between an IT startup and a venture capital company. This thing is fairly short. It's got a lot of really cool Latin words in it, and we'll talk about it. So, Nicole, tell me, why are we talking about this document? Why is it significant? Why should lawyers care about this particular contract we're tearing apart?
Yeah, this is a great sort of typical startup agreement. As Mike indicated, it is short. It's like 12 pages, which in lawyer land, that's really short. And it has all of the things you want to see in a collaboration startup agreement. But when you read through the language, you realize it's a lot of words, but it's not saying anything and it's not helpful. So I thought it would be great to do a teardown on.
Yeah, I'm going to share this thing again because it's hilarious. But before I do, Nicole, tell me about you. I mentioned that you're in the teaching space. Tell me more about your background.
Yes. So I am a professor at Emory Law, and I'm also a director of this entrepreneurship innovation program that we have in partnership with Georgia Tech. So we work with innovators in the Atlanta area, and we help them frame out whatever, it's usually technology innovators. We help them frame out where their technology sits in sort of the innovation ecosystem, so to speak. So what's their value? What are the intellectual property rights they should consider? How can they go to market? And the law students work as consultants. And then there's also some class and academic time that we do to teach everyone in the program how to do this work.
Yeah, and I think you mentioned to me that this one actually came from the teaching experience. And here's why I'm sharing this thing again, because I just think it's so awesome. The first recital, venture, we're again generalizing to the venture startup and the venture capital company and the startup company. Venture is contemporaneously herewith investing $3 million in startup in exchange for a 25% ownership interest in startup pursuant to and on the terms and conditions set forth in that certain Series A units purchase agreement of even date herewith, the purchase agreement, and the other documents referenced therein. I love this so much because it's like if the Dilbert guy was going to write a contract, this is what it would look like.
This is pretty much like contract bingo for what you shouldn't put in a contract and how many words can I use that really are unnecessary and add no value to the document.
And we are going to jump therein See what I
That's
did?
perfect.
We are going to jump there in and go down to a couple of parts that I think are interesting. Can you tell me, I gather, and tell me if this is right, that there are two companies here, and one is like an IT services company, and the other one is a money company. Did I get that right? So the company that's doing the selling, are they doing software, or are they a services company?
Yeah, so the startup created an app. So this looks more like an IT service that they're providing. And they are collaborating with their bank, so to speak, right? So the VC firm is investing in the operation, but this agreement is the collaboration agreement that they have agreed to with the VC firm, which also, I should point out, highly unusual.
Hmm.
Usually the VC firm is literally like your ATM. We just want to get money from you. We want you to leave us alone while we go build, do. You can come check in because we understand you care about your investment, but you're not my collaborator. I'm going to collaborate with a third party. That's what makes this also an interesting agreement to look at. But we're going to take a look at two of the clauses that I think are problematic
Yeah,
for
and
that
on
reason.
that, on that, like them getting intermingled into the business, we're going to jump down to 6 and 7. And it's because it has to do with, the inventions, with the product of the work of this company that, normally they're not this entangled. So let's jump down to 6. It talks about future innovations. And this is a heck of a paragraph, but it just starts that the parties hereby agree that venture shall have a right of first refusal to exclusively, for what was it, a 20% stake? Am I remembering right?
25,
25
25%.
exclusively collaborate directly or through its applicable affiliates with startup to develop any future applications. And it goes on. What about this paragraph is standing out to you?
Well, they have the right of first refusal, which by itself is okay, but it's the right to collaborate. So normally when you see a right of first refusal, it's for an offer, right? For a purchase or sell or something like, look, we want to get in on that deal first. But it's this right of first refusal to collaborate. And the problem is it's on future innovations and they define collaboration very poorly. So if I have a conversation with you at Starbucks, think of it as pre-pandemic where we could actually go inside
Right.
and sit.
Right.
But is that a collaboration? Do I have to have 2 or 3 conversations with you in order for it to trigger this clause? Like the events that would trigger to me are problematic. And as a startup, you don't want to be handcuffed so strongly that you can't even collaborate. I understand you don't want us to enter into another agreement, but can I talk to other parties? Like that's your whole point as a startup. You're trying to grow your business. So it feels very much like an exclusive relationship. Even they're saying it's a right of first refusal, right? So it sounds more open, meaning we just want to know so then we can say no and you can go on your way. But it's really more entangled than it looks on the outside.
Hey, everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Yeah, and there's notice provisions in here. They've got to let them know within a certain amount of time. And then, they've got 30 days, all written notice. And then if they don't get a response, they can go ahead and collaborate with such other party as it determines with respect to such future application. It really is a relationship that seems, pretty. This feels like a joint venture, not an investment.
It very much looks like and sounds like a joint venture opportunity and not an investment. And it's the collaboration that the VC firm is trying to protect, right? So the language of the agreement is written very much to protect the VC firm
Mm.
and their interest from being, well, I guess essentially diluted, but the startup running around with a bunch of other companies and forming other relationships. One of the other troubling parts about this clause is okay, so they have the right of first refusal um, regarding any future innovations, but what does that mean? So, any future innovation that significantly enhanced or improved functionality. Well, how do we measure that? So if is it, like my software updates on my iPhone, is that a significant enhancement or improvement of functionality, or is it just to fix some bugs, right? Which is what Apple always says, they're fixing some security bugs. Would that be a significant improvement in functionality? So the terms are loosely defined where I think this startup essentially anytime they talk to anybody, they're going to have to get their VC firm to approve it. That's
Mm.
how I would interpret it if I were in-house counsel and, I'm on vacation and they come back and they say, Nicole, guess what? We signed this agreement. We were trying to move fast and save you some heartache. And I just go hit my head against the wall.
Well, and this addresses getting to seven, a theme that has come up a lot with modern contracts, which is data rights. That there's data that's being generated in the operations of each of these companies. So looking at it says that startup will provide venture in a format that venture wants access to aggregated, anonymized market and transaction level analytics generated by the startup platform. Again, data is worth a lot, and it seems like this venture company is really getting their hands into it. What do you think about this Section A?
So Section A, sadly, I think tends to be common. So this data rights section, I think, it starts off as what you would expect to see in a data rights exchange between two parties.
Mm-hmm.
But what's troubling is why does the VC firm need anonymized market and transaction level analytics? So, again, I'm questioning you're collaborating with your VC, and the VC is asking for a ton of stuff from you. What are they doing with this additional information? And should you value their investment differently because they're getting additional value from you that you're not really monetizing correctly? And then the one thing that I thought that triggered you would need some further sort of vetting and diligence. Does this data clause satisfy sort of some of our national jurisdictions? So California comes to mind. Can you do this under California law?
Right.
I don't know. But it just triggered a bunch of other obligations on the part of the startup.
Yeah, or Nevada, or theoretically, if they have international operations, the GDPR. And relatedly, in B, it talks about not just anonymized data about the performance of the specific thing that they're creating, that they're entering into this agreement on. It also says such specific data relating to customers of venture and its affiliates, including the business performance of venture and its affiliates. And it adds this nice little sentence at the end, for the sake of clarity, because clarity is clearly one of the strong suits of this document. That was my sarcasm emoji. I don't know if you saw that. Startup may provide similar data that relates solely to the customers of any other user of the startup platform for a similar internal use by such other user. That was a heck of a sentence for clarity. What do you think about B?
Oh my God, B is a train wreck. So that last part just it feels like a Trojan horse. It's like, while you're in there looking at that data, if you could just kind of get me some data from like my people, and then, if you see anyone else's data you think that I might want for the sake of clarity, just send that on as well. I was like, oh, okay. And
Yeah.
this is one of the things that, that consumers hate about contracts, right? You have to read every line, people, every line. So it starts out sounding reasonable, and then you get to, the Darth Vader request at the end, and you're like, and here's why this contract is bad.
Yeah, that for the sake of clarity sounds like the phrase with all due respect, because when you say that, you're about to say something terrible and disrespectful. And if a lawyer starts in a document for the sake of clarity, whatever's coming after is a jumbled mess. Speaking of going to C, it talks about during this term, getting more data, specific data relating to customers of Venture and its affiliates. That they'll use these data services, provide insights and data-related services to their customers. Startups shall provide the data service exclusively to Venture and its affiliates, and not to any other party for a period of 24 months following the launch of the data service within each target market and applicable follow-on market, right? It just keeps going. What do you think of C?
Yeah, I mean, again, you're getting handcuffed for a 2-year window after the launch, presumably, of the app, but that's not clear, right? It's the launch of the data service within each target market and then the follow-on market. So it's for future markets that you're also obligated to provide exclusively these data insights. It's very troubling because this section, based on these 3 clauses, we've yet to go to the 4th, are obligating the startup to some significant requirements. And It's not clear if all those requirements are lawful requirements.
Right, and even if the venture company is under the same obligations. If you look at D, it says that the startup hereby agrees. So it's certifying. Startup agrees that during the term the startup, will comply with all applicable laws in all relevant jurisdictions, the startup's privacy policies, industry standard protocols, the requirements of any codes in the jurisdiction. Again, it's talking about protecting data, but that obligation seems to be really heavily on the startup, and the sections before seem to undermine what it's certifying here in D. What do you think about D?
Absolutely. D was just sort of like a CYA. It's like, don't forget to tell them to follow the laws that we told them to break in A, B, and C above. No, we will follow the laws of the jurisdiction. D. I mean, if I'm the startup, I'm praising D, I guess, because I could say, I can't do any of this other stuff.
Right.
Because D says I've got to follow the laws of the applicable jurisdiction. But you know how this works, right? So yeah, this whole section is somewhat contradicting on itself and troublesome on many levels.
Well, I wanted to talk to you because you're in this situation at the law school where you're sort of in a clinic, right? You're dealing with these local companies and the kinds of contracts that they're running into. This one came from an actual company that had signed this agreement. So I wanted to talk to you just in terms of general principles about this issue that we've talked about on this show before, the distinction between business clients want to see ROI and any time spent by a lawyer looking through a contract, so you don't want to spend umpteen hours making a beautiful contract, but in response, you get these not very thoughtful copy-paste contracts heretofore therein that has all kinds of jumbledy stuff in there. So tell me about how you're teaching the students at the law school how to think through documents like this. Do they tear them apart, or do they have to roll? How do they explain to the client, it's worth me tearing this thing apart?
Yeah, that's a great question. So it's to answer from the latter point. Yes, it's worth you tearing this thing apart because these obligations could cripple your company, your organization going forward. But I also advise them to sort of think of it as creating a master template or a master document, which to draw from. So some of the good clauses or clauses, if we cleaned it up or changed some of the wording, would be a phenomenal clause to use going forward. That goes in your master, right? So the next time, if you are looking at it from a ROI and and value add perspective. You're not writing an agreement from scratch anymore. Like, I don't think any lawyer does that today.
Right.
But you are looking at, what is it that my client really needs? And I'm only including those clauses in the contract, and I'm including clauses to protect my client's interests, of course. But that's it. And you shouldn't have a clause where it's like, clearly, we don't know if this is applicable under any jurisdiction. And then we say, but you have to follow the laws of that jurisdiction. Those conflicting clauses should not exist. You should have clauses that actually enhance and support one another, and provide clarity as an overall agreement and not contradict each other.
Yeah, I'm not, I don't want to pitch Law Insider's functionality specifically, though the bosses might want me to. But, if you go on Law Insider and you look for a contract of an employment agreement, an executive employment agreement for this type of industry, it'll give you some representative documents, but then you can go clause by clause and side by side, choose from among possible, clauses that could include, you can see highlighted the differences between them. And I think for us, in our shtick, our pitch is that we know you're going to do some copying and pasting, right? Nobody's starting from scratch, nor probably should you in a world of precedent. That would be a little bit crazy. But thoughtfully create, like you said, your master documents. Thoughtfully create a library of documents as you go through your practice by thinking about these different sections. Don't just copy paste, right? You've got more obligation than that. So I'm glad you're teaching the students that. So listen, I want people to be able to follow up with you. Of course, I'm a fan. I follow you all over the place. It's a little internet stalky, but you're so smart. How do people get in touch with you on the interwebs if they want to hang out with you?
Sure. So I'm on LinkedIn, Nicole N. Morris. I'm on Twitter, my favorite new platform, Nicole N. Morris, and the number 3. And those are probably the best places to get at me. Or just go to the Emory Law website and you can shoot me an email.
Awesome. And if you guys want to get access to this document to sort of look through it and find all the Latin words that you didn't know before, that you didn't learn in law school, just go to lawinsider.com/resources. We'll have show notes there. And also, if you want to be a contributor on the Contract Teardown Show, just email us. We're at community@lawinsider.com, and then we can hang out heretofore thereafter. Thank you, Nicole. We'll see you guys next time.
Thank you.